Hey, so in this video, we're going to talk about when an unfunded or underfunded living trust exists, whether or not you have a real mess on your hands. So a big topic in estate planning, when there's just this broad discussion about estate planning, is whether people should use a will to provide for the disposition of their estate or whether they should use a living trust. The idea being, should you leave everything in your name, have a will to provide for the disposition of it, name your executor, and then when you die, your assets are frozen, your executor will hire lawyers, and the lawyers will guide the family through that court-supervised process that's required when somebody dies with assets in their name? Or do you want to establish a family trust or a living trust or a revocable living trust, retitle your home and other assets that would have to go through probate if they were in your name when you die, retitle those to your trust while you're alive so that when you pass away, assets in a trust don't go through probate. You will have named a successor trustee. That trust really replaces your will, and your successor trustee will disperse the assets pursuant to the terms of the trust, and they'll distribute those assets to your beneficiaries of your trust. So a lot of talk out there. In fact, I'll even post a video up there about the will versus trust scenario so that you can learn a little bit more on that. But there's really three scenarios that people, family, lawyers go through. I've been involved in a lot of circumstances under all three of these scenarios. So let me give you the first scenario. The first scenario is I've written wills for many people where we created that will-based estate plan. They left everything in their name, and then when they passed away, the family either came back to me or went to an attorney, and there was that kind of court-supervised probate required in order to transfer the assets from the name of the person died, pursuant to the will, to the heirs. So I've handled many of those will-based plans. I've also been involved in my share of revocable living trust-based plans where we established a trust for the individual or the couple, and we retitled assets into their trust. And then when they passed away, because there was nothing in their name that was frozen when they died, what they owned was in their trust, then neither myself nor any other attorneys had to be involved in that trust settlement or the distribution of the trust assets, because things in a trust don't have to go through any kind of court or attorney involvement. That successor trustee disperses the assets out of the trust. And that's the real benefit of having that living trust, is it avoids that probate process. And then I've also been involved in the third scenario where an individual or a couple established a revocable living trust. And for one reason or another, when they died, perhaps years later, perhaps the trust owned some assets, but when that individual or couple died years later, there were still some assets in the name of those individuals. Those assets got frozen, and so the probate is necessary to get those assets out of the name of the person who died. And there is this, I think there's a perception out there that when somebody establishes a living trust and there's a probate required later when they die, there's this perception that that's a real disaster and that's a nightmare. So my point is that when that's the case, the probate can be much simpler when that living trust exists, even though there's still assets in the name of the trust maker when the trust maker dies. Let me explain. Give you two scenarios. First scenario is somebody establishes what I call a will plan. They leave the assets in their name. In their will, they name their executor. Let's say they have 5 heirs. Maybe they have more or less, it really doesn't matter. But for purposes of our discussion, there's 5 heirs. Those heirs might be children, they might be grandchildren, they might be other people, but there's 5 heirs. And when that will maker dies and the estate's got to go through the court proceeding or the court process, all 5 heirs and the executor may be one of the heirs, but so let's say there's 5 people involved in that court-supervised process. So all 5 of those participants need a lawyer. Now, in many cases, they all use the same lawyer, but all 5 of those heirs have to sign off on some layers of court paperwork. That's where it starts to get confusing, and you start to hear things from one or more of the heirs I don't understand what any of this court paperwork is. I want to make sure I get my fair share. I don't understand what petition means, judgment means, order, letters testamentary, letters of administration, letters of independent co-executorship, affidavits, detailed descriptive lists and inventories. I don't get it. Why are these assets listed and these aren't? I don't know that these values that are listed in these court pleadings are correct. I'm confused. I need to know more. What do I do? So you start to get some of that when there's multiple people involved in a probate proceeding. And then, you start hearing things like, well, I signed the paperwork, all the court paperwork that I was asked to sign, and just because somebody else isn't being as cooperative and on the ball as I am, why am I being forced to delay on everything just because one person, wasn't as on the ball as I am? Or maybe sometimes people say, I don't trust this other person who's using the same lawyer that I'm using. I think I need my own lawyer to review all of these court pleadings because I don't want to sign any of these court documents unless I fully understand anything. And so all of those things are what tends to add to the delay and the expense and the difficulty and all those kind of bad things that you hear about probate. And because you've got multiple participants and they all have to sign, get along, cooperate, understand, be represented. And so that's a big problem that causes delay and additional expense and frustration with probate. But eventually, it gets somehow, forces its way to get resolved. Sometimes there's court hearings that are necessary to do that. And sometimes, the parties' lawyers have to get and work together and attempt to resolve things. And ultimately, things end up getting resolved one way or another. All right, so that's the will scenario. 5 participants. The 5 participants go through that probate together. Now I want to introduce you to another scenario where a person did create a living trust, but when they died, their trust wasn't what we call fully funded. I'll make a link up there to a video that I made that describes what funded or what funding a trust means. So what we're getting at here is person set up a trust, and look, I'm the first to admit if somebody's going to set up a living trust and their intent is to avoid probate, then everybody involved should make their best effort to make sure that when that person dies, the assets that need to be titled in the trust are in the trust. But sometimes those assets don't get, titled in the trust. And I'm going to give you another link to a video that it's titled, If You Have a Revocable Living Trust, Watch This Video Now. And so it talks about how important the funding is. But occasionally somebody dies, not occasionally, often somebody dies, and they have a living trust and they still own assets in their name and a probate is required. Okay, so first I want to talk about the underfunded living trust, and then I'm going to talk about the unfunded living trust. So the underfunded living trust is when someone dies with a living trust. Some of their assets are titled in the name of their trust, and some of their assets are still in their name. So there's going to be a probate required to transfer those assets that are in the individual name of that trust maker. But those assets that were in the trust when that person died, those can go ahead and be dispersed immediately by the successor trustee. Those assets don't have to go through any kind of court supervision. Okay, so that's the underfunded living trust. In fact, some people are just, tell me up front they're okay with that. I was working with a fairly successful, business owner in the last few weeks. And like he told me, he said, Paul, I want a living trust, but not everything I own is going to be in my living trust, or it certainly isn't going to be in the near future. He said, I want to make sure my investment accounts are all titled in the name of my trust, because if I pass away, I want my wife to have immediate access to all of our money. But I've got some rather complex business interests, and my wife's not going to need to do anything immediately with those when I pass away. So if those have to go through probate, that's okay. So that's the kind of underfunded revocable living trust. But let's even go further. Let's say there's a completely unfunded revocable living trust. Someone establishes a living trust and they don't retitle so much as one asset of theirs into their trust, and they pass away, and survivors realize, wow, there's a trust, but there's nothing in it, and there's a will, we got to go through probate. And so my point that I want to make is that isn't always necessarily a mess or a disaster, because with the unfunded or underfunded revocable living trust, there's typically only going to be one person involved in the probate, because that person who established the trust, they also very likely wrote a will. It's called a pour-over will. Again, another link to another video on what is a pour-over will. But in their pour-over will, they likely said that if they own anything in their name when they die, then those assets get poured over into their living trust. But you got to go through probate to get those assets to the living trust. But when you have that scenario, only one participant, because the executor that's named in that pour-over will is very likely to be the exact same person who you named as the successor trustee of your trust. So the probate is the only participant is that one person who serves in his capacity as executor and as the only heir in his capacity as successor trustee of your revocable living trust. Now, all of those other perhaps 4 people will be involved in the distribution of assets from your trust to those 5 people, but there's no court supervision and typically no attorney involvement in that trust distribution. And it's very likely that the person that is named as that executor of the pour-over will and the successor trustee of your trust is likely to be a fairly responsible person who gets things done rather quickly and organized, because that's why they were named as the executor and the successor trustee. So that probate, while necessary, can be much more efficient, it can be faster, and it can be simpler. And then once those assets go through the probate process to be retitled into the living trust, then that person can merely distribute the assets out of the trust to those 5 beneficiaries, or however many beneficiaries there might be. So now I will admit that if you set up a living trust and there was a probate required when you pass away, it's likely that you paid more in legal fees to set up your trust-based plan than you would have paid if you would have established a will-based plan. However, the simplicity and the speed at which that probate can take place, because there's only one participant in that probate from start to finish, can more than offset that additional expense that was paid to establish your kind of trust program in the first place. So really important. Now I'm going to take it at this point, encourage you, hit the subscribe button. It's a red rectangle, and the notification bell. That way you won't miss anything. If you've already subscribed, thank you. That's awesome. We're really trying to grow our subscriber base. And then tune in 10 a.m. Central Time every morning. More estate planning educational videos. What I really like to see you do is hit that share arrow and share it with other people who may be in a similar situation. And then one more thing I'll ask you to do is, if you have some experience, some constructive comments, some information that you'd like to share with people who are trying to soak in as much information as they can, because there's not a lot out there on these estate planning topics. Share those valuable pieces of information in the comments below so other people can benefit from everyone's shared experiences. Okay, so I hope that helps. Paul Rabelais, tune in tomorrow 10 a.m. for my next educational video. Y'all have a great day.